it is fantastic to see everybody here volunteering your time, obviously. My name's Nola Karapanagiotis, consister, a barrister. I practice in a number of areas, including this area, and I have to say that a lot of my learnings, a lot of my growth, a lot of what I've been exposed to has been through this organisation. I probably don't need to extol the virtues or, convince anybody because you wouldn't be here, but when I reflect upon some of my experiences in cases that I've been involved in terms of court work and judicial review, it really has been the most rewarding. We have so many different challenges. Yeah, look, it's a difficult area. It does have its limitations, it has its frustrations, but when you do have somebody going through that process, and if they are successful, there are so many examples, young Afghan child unaccompanied here, went to the RRT numerous times, went to court, remitted, and finally accepted. And so when you hear those cases, because often dealing with court processes, we win and then they go back, it doesn't guarantee success. You might be a bit unsure, you might be a bit disheartened by it, but when you do hear those cases and you experience them, it is just incredible. It really is. So it's wonderful, welcome, and thank you for giving your time to me this evening. I've passed around just a set of notes, and the graph might not be clear on everybody's. I apologise, there'll be a clearer one available. But what I've done is you can see the first page, nothing controversial there. It is the definition of what it is to be a refugee. But I just wanted to clearly spell it out and have it in front of us, because tonight I was proposing, I don't want to double up on what has happened, and as I understand it from Con, you have been focusing on just a number of different steps and areas, and he has gone through in a lot of detail about what's important for a claim, what it is to make an application, the elements, the requirements, etc. So I appreciate that he's done that. I understand though that in terms of sources and certain specifics, that has been left until now, so a bit later. So I'm proposing to go through some of the elements, and the reason for that is when we're looking and considering judicial review, it's obviously important that we understand the structure, we understand the legislation, we understand some of, not all because that's probably impossible, but some of the case law dealing with the areas. So as I do understand it, sections of the Migration Act, I'm not going to spend too long on it, but you'll see here, cited some sections under general sections, basic chronology, just so that we understand the differences in status, because again, it has ramifications for the court process. And then last couple of pages, sections relevant to decision making. So dealing with, as you all would be familiar with now, the DAC component, or rather the Department of Immigration first step, and then second to that, the RRT processes. And again, just trying to bring it back to the point that we need to know what the functions are to be able to satisfy yourself that they in fact have carried out their statutory duties and functions. So if I see any really alarmed looks, I'll know that it is repeating what you've already considered, and I'll try and move on quickly. But otherwise, I will just start, first of all, with a broad overview of the elements in terms of that definition, and then go to some of the sections of the Act, just so that we are familiar with the primary source sections, and then we'll move on to judicial review, where we go, when we go, and why we go to these particular courts. And that will probably see us through the night. On the next occasion though, what we'll do is look at common errors that appear and thrash that out with reference to case law. So hopefully that timetable works for all. All right, so the Migration Act and Section 36 2A provides that a person can apply for a protection visa if they are a non-citizen in Australia of whom the Minister is satisfied Australia has protection obligations under the Refugees Convention as amended by the Refugees Protocol, convention relating to the status of refugees. And that's where our definition comes from, okay? And first page, we look to that definition and we can see that there are a number of elements. Owing, and I've highlighted some of them, but owing to a well-founded fear of being persecuted, first element, well-founded fear, for reasons of, you can immediately see there, for reasons of, there's a causal connection required, race, religion, nationality, membership of a particular social group, or political opinion. All of these elements have been considered time and time again by the courts. There are leading High Court authorities that are good to familiarise yourself with, and then it is helpful as well just to go to the Federal Circuit Court website, have a bit of a look around, go to the Federal Court website, key in some key terms, and I found that that's a really helpful learning tool. In terms of those different reasons, the race, religion, etc., a lot of them won't normally cause us too much difficulty when you're advising, giving a merits review, going to court. Probably the most contentious, I would have thought, is membership of a particular social group. But we will definitely come to those issues and consider what is capable of comprising such a social group. Examples, family. Examples, women. Many different examples there, important to know, because if we have an RRT decision, for example, where they have made a finding that the particular group alleged is not capable of forming a particular social group for the purpose of the convention, that may be an error. So we can see how it's all very linked. Continuing with the definition though, is outside the country of his nationality, not going to be a problem, and is unable or owing to such fear is unwilling to avail himself, herself of the protection of that country. Or who, not having a nationality, being outside the country of his or her habitual residence, unable, owing to such fear, unwilling to return to it. So, guys, we see here clearly different elements, and the first one which would stand out to you all is well-founded fear. And in the preceding training sessions, no doubt you guys have looked at particular cases, have been taught the issues to focus on. I think all I probably need to say about that element at this stage is it contains two parts to it, subjective and objective. In a tribunal decision, you will, some of them vary, but they do, I don't know, has anybody read a tribunal decision or seen one? Yep, a couple of you have. Sometimes they're quite formulaic, and they actually they'll start with this definition, and they'll start with breaking it down. They'll start by citing some of the High Court authorities. What we have to bear in mind is usually if you've got a decision and they've recited the law correctly, the inference, I guess, is they've applied it. But if there's no more than that, and if you're reading something and you think, well, hang on, they got this in application wrong, just because there's a recitation of the formula doesn't immunise the decision from review. So I guess that's always, it's never helpful, and there are many times that respondents, I think, will say, well, it appears here, but it always does. There needs to be a bit more substance or application to it. Okay, but well-founded fear, subjective element, not often going to be a problem, I would have thought. Sometimes it does arise. If somebody's travelled to Australia before or elsewhere or has delayed in making a protection visa application, it might be an issue. But in my experience, it's not commonly an issue. What is commonly an issue and involves a number of different considerations is the objective element to this issue, to this element here, well-founded fear. There needs to be an objective basis. And what does that mean? In terms of what that precisely means as opposed to a factual scenario, can any of you, has this been canvassed in terms of, you know, it doesn't need to be 50%? Has this been discussed as a group? Yep, okay, so you all know then that really what I think the case law talks about is it not being, you know, remote or far-fetched. Is there a real chance of persecution? And the leading authority there, you don't have to worry too much about getting the cases down, because I have very good intentions at the moment, and I'm hopeful of following them through, of just perhaps trying to get the leading cases, put them under categories, and it might just be useful to have. So I'll provide that to you. So with the objective element, again, the factual stuff we won't focus on, but Con would have spoken to you about country information being a primary persuasive piece of evidence, and it often does turn upon country information. But we're more concerned in this session about what does it mean? What is a real chance? What is a decision maker required to do? Because when you know that, it follows that you know if there has been a failure or a misapplication of the real chance test. So I don't think I've come across a decision that does use percentages, because if you're reading a decision and suddenly you see, you know, somebody citing, or decision maker citing 20% or anything like that, alarm bells immediately will be going off. But you might see language like probabilities, you might see language like likelihood, and that language is okay if a decision maker is considering the factual claims and making findings about the factual claims. It's okay to say, look, I don't think this particular claim is likely, or to use that type of language. It's common sense, and we probably all know that in our different areas of law that we practice in, or that we've read about or have been exposed to. That's okay. The difficulty and the problem and the error is when that type of language is used as a substitute or as a purported application of the real chance test. Okay? So I think that for our purposes, it's enough to know not a remote or insubstantial chance. Another important thing to appreciate is there is consideration. I've had a couple of cases on this, and it is an error that I wouldn't rate it high. I don't know how many times it's happened, but I've certainly come across it a few times, and that is, it is a future or a forward-thinking assessment. When you're considering, does this person face a real chance of persecution upon return? Of course, it's forward thinking. A decision maker cannot simply speculate. And the unfortunate thing there in practice, we've seen a lot of, changed circumstances in some countries. Afghanistan troops being withdrawn, there being a claim by many, I would have thought a fairly persuasive and powerful claim that we don't know what the situation's going to be like when that occurs. And I've seen that a lot of decision makers have simply confronted that issue by saying, we can't speculate. Seems unfair, but the decisions I've read on that, on that point couldn't see error, but you can see that there's certainly a difference. A decision maker is not and shouldn't speculate, but they are required to think into the future. So the important thing for us to know here is what approach is adopted. Obviously, looking at the past is a good indicator to see what might occur in the future. But it's not always the reliable indicator. Again, change country circumstances might affect that. But more importantly, just because you might have an applicant who has not experienced direct harm does not mean that they are excluded from the Refugee Convention. And the question isn't just simply, has this person experienced harm in the past? It's a legitimate question. It's open to a decision maker to ask it. And again, applying common sense reasoning, you can see why. You know, it's rational to start there. But if you stop there, then that is not applying the test. And there have been, like I said, a few instances, you know, over the last year or two where that has occurred. They've just confined themselves. It's also important under the well-founded fear element, and I'm still there, but there is overlap often. But it is also important to appreciate that a decision maker is required to consider an applicant's claims cumulatively. Okay? There may be an instance where somebody does complain about having experienced many different forms of harm. And it might be that considered alone, on their own, it does not support a finding of real chance of persecution or indeed persecution. But we'll come to that, and it demonstrates the overlap. On its own, it might not be enough to satisfy a decision maker. That's why there is a legal requirement that it be considered cumulatively. Again, it's something that you will probably see. Going to sound a bit cynical, but I'm sure you got lots of cynicism from my brother. But it is often hacked on to the end of a decision, and I have also considered the claims cumulatively. Again, not a helpful reference if that is the ground that we're wanting to challenge. But if that is the only reference, and it is commonly, a lot of decisions simply appear that way, if it's the only reference and if there's a real argument about combined harm, then again, that token reference should not immunise the decision from review and shouldn't deter you from making a recommendation that it's that, you know, we should give it a go and judicially review it. Now, in terms of in terms of well-founded fear, there's also another section to be aware of, and that is section 91R3. And I think it's in the outline, but I'll just read it out. 91R3, for the purposes of the application of this Act and the regulations, A, in determining whether the person has a well-founded fear of being persecuted for one or more of the reasons mentioned in Article 1A2 of the Refugees Convention, which is our defining section. So may disregard any conduct engaged in by the person in Australia unless B, the person satisfies the minister that the person engaged in the conduct otherwise than for the purpose of strengthening the person's claim to be a refugee. Now again, this issue might have been something that you've covered in the past sessions, because it's something to bear in mind, I think, at every stage. It's sometimes difficult. You just read out a slab, but I just want to really break that down. What that section is really talking about is if you've got a decision maker who believes that the person has engaged in certain conduct here just to strengthen, to support their claim to be a refugee, then that conduct can be disregarded. And commonly at the centre, that type of doubt or scepticism or disbelief applies in a religious context. So you might have example, an Iranian saying that I have converted to Christianity, and I've done that here. Complete legitimate claim, refugee claim, would meet that definition, but you might just get a decision maker who, doesn't believe a thing, and you might get somebody who has legitimate reasons for questioning that claim. I think what we are exposed to, because when we're going to be looking at this area and at decisions, you're not looking at the positive decisions, but there are positive decisions, and there are some tribunal members that certainly know what they're doing, and people are being accepted. We are looking at the claims that are being rejected, and I think, provoke some fairly emotional and colourful reactions when you are reading a decision or listening to an RRT hearing, and you just think to yourself, the decision maker is starting from the point of disbelief. And it's not uncommon in this area. And so you might, in terms of this section and its application, there might be legitimate reasons, but overall, this is the context that we are operating in, and so this section is something to be aware of because it is applied, not irregularly. And at the beginning stages, when you're doing your stat decks, when you're talking to a client, if you get that kind of claim, you would want, you're going to church, what are you doing, get letters, you'd want all that supporting material at that stage. And at the later stages, when merits review and the merits process is over, we will want to be considering for ourselves, well, has this section been applied correctly? It is an unusual section in that it does place, and you can hear it from the language of the section, it does place an onus on the person to prove it. And if there are multiple reasons, for example, if there are multiple reasons, one of them includes trying to strengthen your claim, then that doesn't automatically mean that this section is invoked. And you can see that it has severe consequences. This is basically saying you might be at risk upon return. You might have been on video, you may have been shown, you may have done blogs, you may have done A, B, C, and you will be at risk. We're going to disregard that. So it has really serious consequences. But if you get that finding, there are a number of reasons, and this is one of them, and you've got a decision maker invoking the section, that, as an example, there are many, but that might be something that you could look into and something to argue. In terms of the onus, like I said, you can see from the section that it does place it on the applicant, but generally speaking, in this area of law, there is no, and the decisions don't talk about an onus of proof on the applicant. Clearly, it is for an applicant to make their case. Okay, and there are many decisions where the courts have found it's not for the tribunal or the decision maker to make the case for the person. It gets a bit complicated because it's certainly for the decision maker to consider what is before him or her. It's not just a matter of, particularly unrepresented applicants, just because they might not tick the elements off and make it as plain or as clear as that doesn't mean that a decision maker shouldn't do that. So it's not, and we will talk about this more when we get to specific areas next time, but just remember that overall and generally, putting aside 91R3, there is no onus of proof if you get a decision where that is mentioned. The applicant, I had one, the applicant didn't present any documents confirming his education. The applicant didn't present witnesses. The applicant was unable to do this. If you get that kind of language, and if it is repeated, if it's once or twice, again, it's a matter of degree and assessment. You're probably unlikely to get there. But if you get that language, the onus of proof language, and if you get that repetition, littering a decision, that they've not provided A, B, C, D, then it might found error. It might be a basis to argue it. So that deals with well-founded fear. The other thing that will factor into well-founded fear is demonstrating yet again the overlapping nature of these elements, the ability to access state protection. And you can see that's a separate element here, but it is something that, again, using your common sense, you can see that it does affect that element. Is the fear objectively well-founded? Is there a real chance, well, the state can protect the person? That impacts on the consideration. Moving on to persecution. So owing to a well-founded fear of being persecuted for reasons, I think I've noted in, it seems to be missing from my list, but in terms of the Migration Act, when you're considering persecution, 91R1 is the section, and the Act, or that section, is not designed to displace the Convention definition, which we have. It is designed to clarify, and it does not provide an exhaustive list. Can I say, guys, before I do move on to this, can I just say one other thing about 91R, the exclusionary provision, if you like? That doesn't apply to complementary protection. So we know that section 36, and I'll talk a bit about complementary protection, but we know that now you've got it based on the Refugee Convention, and then second to that, complementary protection. 91R does not have application to complementary protection, and there have been a couple of cases, certainly that I've seen at the centre, where it has been applied, because what the decision maker has done is they've disregarded conduct in Australia in the convention-related assessment, and then complementary protection, and typically complementary protection usually takes on about 2 or 3 paragraphs, not always, but what they usually do is say, I rely upon the foregoing, reasons. It has equal application here. And if you get that kind of decision and there hasn't been any further consideration, then that would be an error or certainly something that, you know, alarm bells again should be going off. All right, so I'm sorry, I'll come back to fear of persecution, section 91R1. Yeah, it might not be on there. Oh, is it? No, okay. Anyway, you can take a note of it. Provides that for the purposes of the Act and regulations, Article 1A2 does not apply in relation to persecution for one or more of the Convention reasons unless. Okay, these are the elements. The reason, that reason is the essential and significant reason, or those reasons are the essential and significant reasons, and the persecution involves serious harm. That's probably a term that's been floated around over the last few sessions, serious harm, persecution. I'm just bringing you to this section because this is its source along with the Convention definition, okay? Persecution involves systematic and discriminatory conduct. And that is, I'm just quoting from 91R1. 91R2 then has a list of non-exhaustive forms of harm. Threat to a person's life or liberty, significant physical harassment, significant economic hardship. But again, that's when we're dealing with, for reasons, owing to a well-founded fear of being persecuted for reasons of. That's a good example in terms of, I mean, obviously, significant financial harm and hardship is capable of amounting to serious harm, but to fall within the Convention, there obviously needs to be that nexus. Destitution, hardship alone, without it being for a Convention reason, without it being simply something that might be, oh, it's probably not a good example, I was going to say random, then that will not fall within the Convention. But anyway, 91R1 and 2 is a section that, have a look at it, it does outline that list of about 5 or 6 matters, and it does provide for the elements that I've just spoken of, which is essential and significant reason, so the Convention reason needs to be essential, significant, persecution involves serious harm. And as far as decision makers go, a lot of these assessments and determinations are, it's a factual assessment, yeah? So it's something that a decision maker will look at a variety of different pieces of evidence, listen to the applicant's evidence and make its findings. But again, we're concerned here in this structure of, well, what do these terms mean and how should they be applied? And again, look, the Haji Ibrahim is one of the High Court leading cases, which pretty much reiterates that idea of it is a matter of serious harm degree. Much will depend on the form and extent of the harm. While persecution always involves the notion of selective harassment or pursuit, selective harassment or pursuit may not be so intensive, repetitive, prolonged that it can be described as persecution. So again, that assessment. But although it's a factual issue, if you have a decision maker, if you've got a case where it is on its face a clear form of persecution, then I think your starting point needs to be a recognition of that. And then the inference that you're going to draw is they must have applied this test wrong. You know, you work backwards in a sense. That's maybe not, I don't know, again, it does arise from time to time where you look at it and you just think, well, how is this not serious harm? So I think that the way in which you would probably try and argue that is to work backwards, and even to make that argument that given that finding, the only inference is that there's been a misapplication here. This is where, when we're dealing with persecution and that causal connection, a person is not required to avoid persecution or to take steps to avoid persecution. They're not required to act discreetly. High Court, one of the High Court leading authorities dealt with the issue of an applicant who was gay, and whether living discreetly and avoiding persecution therefore meant that they did not fall within the definition. Now that is clearly, and certainly according to the High Court, not correct. It's a misapplication of the test. I had the interesting experience once of reading a primary decision where it was for an unauthorised maritime arrival, so it wasn't in the Migration Act. It's a bit separate, and we'll come to that as well because there are still a couple floating around here. But I had the RSA, which was the primary decision, and he was dealing with this applicant, and he basically, it was terrible. He acknowledged the High Court, this particular High Court case, and he was saying, well, I know that I can't do this, but effectively, really, you should be aware of the moral compass and codes in your society, and therefore you should live discreetly. It was just acknowledging what the law was, and then perplexing. Then we got a second decision, and so the next step, which was the IMR, which found against the applicant, but not for that reason. And I remember just thinking, oh, you really wish there wasn't that next decision, because you'd love to take that to the High Court and, make this person accountable. It was just terrible. But anyway, just bear in mind that you don't need to take positive steps. And it doesn't only apply to sexuality, it applies to, you might have somebody with a political claim. Again, well, if you're not as vocal, or if you take a rest from demonstrating, or you can't reason like that. And yet it does, maybe not as obvious as the example I've just cited, but it does happen. I had a hairdresser once, it sounds a bit odd, but he was from Iraq, and the whole issue there was imputed political opinion, membership of a particular social group, and what it meant to be stylising, Western haircuts, and what we obviously take for granted, but implications there. And the decision maker there said, well, you can change jobs, move on, and that was found to be one of the many errors in that particular case. So be aware of that. In terms of that phrase, taking you back to 91R1, I quoted to you the essential significant reason, serious harm, and I quoted the phrase systematic and discriminatory conduct. Now, just so you have a general idea about what the case law does say about that, it is not that it needs to be, an applicant has to show precisely how many times. An applicant can suffer serious harm even if it is one incident, okay? And it is meant to convey, what the case law generally says, is it's meant to convey non-random harm. So you might have a decision where certain things have happened. A person has been arrested in Iran during the demonstrations and has been detained and questioned. Now that, on its face, serious harm, but sometimes decision makers might look at it and say, well, it's confined to the political turmoil at that time. I guess that impacts on real chance, whether there's a well-founded fear. So if they confine it to a period, it's unlikely to occur. Or if a person's arrested for drinking in Iran or something like that, they might consider that to be non-systematic, more of a random form of harm to a person. But just bear in mind, because the language, I think, it's a bit overwhelming, like when you read systematic and discriminatory conduct, but you don't need to go that far. There has to be some deliberate motivation. We had a case, one, I've just cut and pasted a couple of them just so that I can cite them to you, but there was one that the centre ran actually here in front of, at the Federal Court, VSAI, and she had been conscripted into the army, Ethiopian, I think. I am also looking across the road at the Ethiopian restaurant, but I think Ethiopia, Eritrea, anyway, and there was a claim there on her behalf. She was this young woman claimed that she was at risk of sexual violence and at risk of being raped, and the country information was pretty solid, but there was a finding there that how many times would it occur, how many times would it happen, what's the degree of it. That's where the decision maker was focused, and Her Honour Justice Crennan, sitting on the Federal Court then, basically said, look, when for the purposes of section 91R 1C, it would be wrong to require the applicant to show anything more than that it's deliberate or premeditated, that is motivated. It would not be necessary to show that the conduct is widespread or frequently recurring. However, the frequency, the regularity is relevant to the issue of serious harm. Of course it's relevant, it's not the deciding factor. So when we start to get a bit familiar, and it's only that, I mean, I find that with these decisions, you can read them over and over again. It goes around in your head many times. It's helpful to talk to others, which is what all you guys will be doing if you're sitting down with a decision and being asked to look at it and provide your opinion. I think that's always helpful, but it is good just as that, for that solid, I guess, basis to start off with, having a general understanding as to what our convention terms mean, because errors are often found and lie there. Okay? And it's also helpful, I think, because sometimes you might get a decision where some of this isn't considered, and that's a very common ground of review, is a failure to consider an integer of a claim or a failure to consider a claim. And it might be wrapped up, I mean, you know what's the function here, what's the duty, what's required. This kind of stuff is required. And if it's not there, if it's absent, then again, it may give us something to work with. All right? And I think my practice has always been, and again, I mentioned some of those cases that really have a huge impact or can have an impact on you as a practitioner, but my practice has been, you know, if I think there's something there, and again, I'm not standing here encouraging you guys to just run anything, but if I think that there's something there, if I think it's arguable, I'm not going to give a percentage of it's 90% chance, or if I think that it is arguable, then I will generally advise that we should pursue it. And that is because, in my experience, sometimes those matters do get up. This is a flexible area. There's certainly law that applies there, but you've got to come to it with a bit of creativity. There is a bit of scope, notwithstanding they've tried to really reduce that scope that's available to applicants. So I just think that, you know, given what the consequences are for our clients, given how grave the consequences are, if you think it's there, then you should run with it. Now, that systematic conduct. Now, in terms of discriminatory, and that appeared with, so that third element, persecution involves systematic and discriminatory conduct. Again, it really highlights or repeats the causal connection. You know, it has to be for these reasons. It doesn't only have to be for that reason. Again, another area that is sometimes the basis for a review application, and that is a person might target somebody because of their ethnicity. They may equally do so because they're greedy and it suits them. They've got financial interests and motivation. That doesn't mean that it doesn't come within the convention. So again, if you get a decision maker finding, well, I think that the motivation really lay here, doesn't go on to consider the other claims or what else has been said, or positively excludes the convention applying because that's one of the reasons. If you get something like that, again, an area to look into further, it may be capable of review. Now, in terms of persecution and this issue of discrimination and harm, you can have a situation where a person is being seriously harmed by an individual, and it's not convention related. I mean, often in the work that we do, it's the state. You know, a client will say, well, it's the military, whatever, but it's often a state agent. It's not to exclude that it can't be coming from an individual. Kawa's case in the High Court, a leading authority, Khawar, I think, but again, I'll note that, a woman. And it was claimed there that she was a survivor of domestic violence and could not be protected by the state or the police, who were motivated to not protect her for a convention reason, in that case, a particular social group. Other cases that you could think of, it could be a personal vendetta, it could be somebody in Afghanistan having a property dispute, but the state agents may be unwilling to protect because the person is a Hazara Shia, convention related. That would bring that private type of harm into the convention. So private harm, state withholding or selective withholding, if you like, that can bring us in there. And again, just be aware of that because it's another area that a decision maker might not get right. So I think just to recap, because the purpose, hopefully, and particularly when we're done over the few weeks that we've got together, because next week I've got here jurisdictional error, procedural fairness, remedies, common issues that arise. Hopefully some of these matters, and I will try and design it that they do arise again, that we think of them in a bit of context, because I don't want to just cite elements and things and overwhelm anybody with any of that. But just to recap here, what we've simply done is looked at that definition, looked at key elements and what the law has to say about some of them. So, well-founded fear, our subjective element, our objective element, what that means, ways in which a conclusion in relation to that issue should be formulated, the tests that apply, and then persecution, the causal nexus, not the only reason, a reason. Just be familiar with those broad concepts and the sections of the Act that do apply. Okay? So moving along then, well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group. As I said to you, this obviously includes imputed as well. So all of these categories also include being imputed with that, because a person might suffer some harm or be persecuted not because they are of a particular nationality, but they're perceived to be. And likewise, not because they are a member of a particular social group, but they are perceived and imputed to be so. So just, maybe in a bracket, add the word imputed there. In respect of membership of a particular social group, I will provide some of the cases in that document that I was talking about, because what the law generally says is there has to be common features, unifying features to bind the group and make them identifiable as a group. So a particular social group, you will be identified as part of this group. And what the High Court says is, well, the persecution itself can't be that binding force or the identifier, although, and they use the example, left-handed person, just because left-handed people are persecuted doesn't make them a particular social group. It needs to be independent of that. But they do say, though, that the more you persecute left-handed people, the more they are likely to be identified in the community as being part of this group that is persecuted. So it's not exactly clear-cut, but that is a common example that's cited when the point is being made about persecution not being able to define the group. But a particular social group really can be, it can be hairdressers imputed with westernised opinions. The case I cited earlier, failed asylum seekers is a very common one. Drednignikov's case, High Court case where it was the businessman who ran his case, and he had particularised, he had stated his group in a very particular way. I don't have a note of it here, but it was businessmen who are imputed to be informers or involved in corruption. There was a specific way, and the complaint there was that the particular social group hadn't been considered. His claim, as put, hadn't been considered. Only businessmen had been considered, which is a much broader group, and which obviously, the broader the group, you can see how that causal component probably stretches out and gets a bit more difficult to meet. He was successful, and it's a really, it's an interesting one. I think he represented himself in the High Court, which makes us all feel redundant. But it's a really good case, and it is a leading authority on this issue. So membership of a particular social group is something, if you've got a case dealing with that, it's definitely something that you should really look at in terms of the finding, is the person capable of being part of it? The decision maker might be wrong about that, might exclude them when, in fact and in law, it is capable. And then there might be error when considering that causal nexus. Oh, can somebody open that door? No? She's gone around. Okay. Now, I'll just move on then. There is some case law dealing with race, religion. Religion does also include, and there have been cases here of not having a religious belief, not so either abandoning it, apostasy, so it can come in a variety of different forms as well under religion. But there are cases that deal with that, and maybe we'll look at some of them next week, but we'll focus on I guess, what the more common issue is that arises. Now, moving on, outside country of nationality, that is not going to be a problem for us. Unable, owing to such fear, unwilling to avail himself of the protection of that country. And again, in terms of that element, when the person fears the state or a state agent, when they are the persecutors, that is not going to be difficult. When it is an individual or private harm for a convention reason, it might arise. And if the state, if it's a country where the state is able to protect the person, and issues that will be relevant here is whether, in terms of considering the unwillingness, whether that is not so much well-founded, but rational, persuasive, related to the various convention reasons. But it doesn't arise as a common issue, but it might arise where you're dealing with an individual or harm that is private in nature. In terms of adequacy of state protection, how adequate is that protection? It's another issue that will obviously arise, and there is case law on this. What type of protection does a country need to afford its citizen? And the case law does say it's not absolute protection, it's not a guarantee of protection. It's the case of S152 of 2003, High Court, is again a leading case on this, refers to the obligation of the state to take reasonable measures to protect the lives and safety of its citizens, including an appropriate criminal law, the provision of a reasonably effective and impartial police force and justice system, and a reasonably effective police force and reasonably impartial system of justice. So, look, you're not going to get this as an issue if you have an asylum seeker from Afghanistan, for example, who is saying, I am being persecuted because I am Hazara. If there's a finding that is positive, I would be very surprised if a decision maker then goes on to make a finding that all is well and protection can be afforded. Although that does obviously happen, and it usually hinges upon the country information. Sometimes what you hear from a client, what you know through your own resources and your own connections, completely at odds with the formal country information that will often, I mean, Kabul, according to this country information, is the place to go. It's a holiday resort. I mean, it's extraordinary. Relocation, you might be unsafe in Afghanistan. You're unsafe in the region, in the Jaghori region. Go to Kabul. It is extraordinary, but from our point of view, very difficult if the country information supports that. And as we know, if there's a finding that a person can relocate, then that's the end of the matter, unless the relocation test, and of course there's a test that underpins that, and there's case law on it, unless that has been misapplied.
Aren't we in a bit of trouble, with that country information? Obviously it's just so easily manipulated by a government that doesn't want to grant asylum. And what are the objective standards for the country information?
Yeah, look, I agree. I agree with you. It is like that. What I can say is, in terms of country information, it is for the decision maker to pick and choose the information relied upon, okay? That is the bottom line. And often the information that I agree is just, it misrepresents. It is often from considered reliable sources. At the primary stages, before we get to this stage, I've always suggested to people, and I see it happening sometimes, get your own academic, get an expert in the area, do something like that, get a statement, put that in to support a person's application. Be a bit more, thoughtful about it. Try and get other information in. But at our stage, where all that has happened, and at this stage it's very frustrating because you do see some applications that you just think this person did not get a fair hearing. They were not properly represented. And it's distressing. Like, I've seen statements, none by here. I mean, the ASRC is really incredible in the work it does, but I've seen statements of an applicant, their entire claims that go for a page. I've seen submissions where it's all cut and paste submissions of country information that don't, think about it, any kind of argument you make, you need to relate it. You don't just cut and paste something, put a 40-page submission in, and then say you've done a good job. I mean, it's outrageous. But to move on from the first point of country information for the decision maker, it's not black and white. There might be some scope. For example, if it is completely unbalanced, and if you do have an applicant who has put in information countering that, and if that information hasn't been considered, so I'm not just talking about one article, it's not going to get you anywhere, but if you've got a decision maker who quite clearly has just adopted and considered one set of information and not the other that was before him or her, that might be an argument. It might be an argument that they've not undertaken the statutory function and duty that they're required to, which is to assess the person's claims under Section 36A of the Migration Act. Are they a refugee? Do they meet this definition? So you could perhaps, consider that, and then you might get a case, I'm waiting for a decision on one where it's overwhelming that the information did support the applicant, but you get into very difficult and strained territory there, unreasonableness, no evidence. We'll come to those grounds later in the other sessions. They're very, very difficult to argue. So country information is hard. That's why a lot of the good work, I think, needs to be done earlier rather than later, where we are left in a situation that if it turns on that, a relocation finding, because Kabul is fantastic, it's going to be hard. And if it turns on a relocation finding, then even if there were errors anywhere else, and there was clearly a finding that your client's a refugee, otherwise they wouldn't go there, but even if there are any other errors elsewhere in the decision, it's not really going to matter. What will matter is that relocation finding, because that's what the decision turns on. Yeah.
It doesn't matter in terms of substantively, that gets remitted to the ASRC, they're still going to say they can relocate, or you say that a court will just say those errors were not substantial enough for me to remit the application.
Yeah, more the latter, not so much substantial, but I guess just inconsequential. What's the... Unless you can sometimes get some decisions where there's an adverse finding on the refugee claim, then they go on and say, in any event, I find that the applicant can relocate. So, making sure they cover everything. If they've done that, then you would attack both the relocation finding and the earlier finding. You'd attack both, because you wouldn't want to be confronted with the argument against you, which is, well, you weren't happy with the earlier finding, it's fixed and cured by the relocation one. The point I was making in my example is if it does turn completely on relocation, you would need to find an error there. I'm not saying the rest of the decision's irrelevant, but it'd be very difficult, I would have thought, to argue another error that ultimately had no real consequence.
So surely in that, I don't understand how it works in that circumstance. If Kabul always meant to be fantastic, but there's a particular reason that this person, say because of their nationality, is a refugee, then relocating to Kabul in that instance is not going to help them because of lots of resort towns, it's their nationality that's caused the issue.
That's the type of argument that will be made for an applicant. There's also a reasonableness test. It has to be reasonable. So when looking at relocation, there are many authorities, which I'll cite on that list, that deal with, a person might say, no, if I move anywhere else, I'm still going to be persecuted. In answer to that, they might look at country information. There might be a case where they consider the harm to be localised. It's the region. And there's a lot of information, for example, on Afghanistan that deals with particular regions where the Taliban are. It does turn on geography. You might have an applicant who says, well, I have no family supports there. Nobody, if I return to Kabul, all my supports are in this particular district. And my children are there. You might have all of those matters. That goes to the issue of reasonableness. That needs to be considered. So there's some scope with relocation, but it's always struck me as a hard concept to get my head around, because you are finding that a person's at risk of return to their country, but it is fixed by finding that they can relocate. But it is part of the law. It is what happens. It is applied. Okay? Complementary protection. Con said that you didn't spend a great deal of time on complementary protection, so I thought that I'd just cover that a bit now. And what we do with complementary protection, we basically go back to Section 36 of the Migration Act. This was only introduced in March of 2012. And Section 36 2AA. So, a criterion for a protection visa is that the applicant for the visa is a non-citizen in Australia, in respect of whom the minister is satisfied Australia has protection obligations. 2, under the convention. We have all just gone through that now. The next element is AA, a non-citizen in Australia, in respect of whom the minister is satisfied Australia has protection obligations because the minister has substantial grounds for believing that, as a necessary and foreseeable consequence of being returned, there's a real risk that the person will suffer significant harm. I'm going to come back to some of these elements, but you can see just the way in which Section 36 is outlined. What a decision maker first does is considers the convention-based claim. If a favourable finding is made, that will be the end of the matter. They obviously don't need to go on to consider AA. If it's not the end of the matter, then they do press on and consider complementary protection. And it is certainly different to convention-based protection because it doesn't include all forms of significant harm. It is fettered in many ways and narrowed, but you don't have the need for the causal connection for one of those reasons that we've gone through: race, nationality, membership of a particular social group, etc. And like I said, certain provisions like 91R3 don't apply. Okay, so it is different, but in some respects, similar types of questions are asked when you're considering complementary protection. Now, real risk, there was some debate about all of that until it was resolved, by the courts. Real risk essentially is real chance. It's the same type of test that we were just discussing in relation to convention-based harm. So, significant harm, it is defined in the section, okay? So 36, when you go to it, you know, in Auslie or wherever, it exhaustively outlines for us what this harm is, significant harm. Then definition sections clarify and add further to those elements, okay? So, is there a real chance that a person will suffer significant harm? Significant harm if the non-citizen arbitrarily deprived of his or her life, the death penalty will be carried out. I might say in relation to that one, I guess that's pretty clear cut. Will be carried out though, so it's not just, again, a matter of speculation. The difficulties though, and I think a lot of people, RILC and a number of other organisations, have had people coming under complementary protection based on criminal type matters. And that is, if I go back to China, I'm going to be executed, things like that. The difficulty they have been facing, or those applicants face, is generally in refugee law, there are exclusionary provisions, and they are provisions that basically provide if you've committed a serious crime, for example, in your home country, you're not going to get our protection. So it's the government governing or protecting who is allowed to stay in, obviously, into the country. So we've got Article 1F, which applies with the Refugees Convention. Okay, Article 1F, if that applies, you've got a whole process that you go through, AAT and later on. There's also a similar process or similar thing that applies to Section 36AA, so complementary protection. And so I think that is being invoked from time to time, and it's not so much the RRT that decide that issue. They remit it back to the Department of Immigration, who will then invoke this, and then there's a whole different process. And maybe on the last session, during the last session, we'll go through that, because the Centre had a recent Article 1F case in the High Court that was really interesting, and this is kind of the equivalent provision. So it's worth knowing, just because complementary protection does bring up those issues of, you know, crime and whether a person's going to be punished and to what extent. Further on though, moving on from the death penalty, you've got C, torture. The non-citizen will be subjected to torture. D, non-citizen will be subjected to cruel or inhumane treatment or punishment. Or E, the non-citizen will be subjected to degrading treatment or punishment. And then some familiar qualifiers that follow, because they apply in the convention area. There is taken not to be a real risk that a non-citizen will suffer significant harm. If the minister is satisfied that A, it would be reasonable for the person to relocate, maybe to Kabul. B, the non-citizen could obtain from an authority of the country protection such that there wouldn't be a real risk. So that issue of state protection features here. And C, the real risk is one faced by the population of the country generally, and not faced by the person personally. So again, that really in a way is incorporating the causal nexus that we have in the convention area, you know, for reasons of. That's the way it's incorporated here. So there are qualifiers. I won't continue, but later on in 2C, you've got the exclusionary, you know, criminal behaviour type stuff that I was talking about. Torture, when we look at what is capable of constituting significant harm, we then are referred to in the Act to the definition sections. So Section 5.1 defines torture. And that section defines a number of different elements when we're dealing with complementary protection, including inhumane treatment or punishment. I won't recite those because I want to stay focused on the convention part of this, but I will just mention in relation to torture what or how it's defined, because when you think about that definition, you can see how it incorporates things like intention, things like motivational acts, important elements that are injected into that definition, I guess, to confine its scope. And complementary protection isn't just about, well, I'm at risk of significant harm, protect me. It's a bit more confined. Having said that, though, it is a relatively, I mean, they tried to abolish it, didn't they? And maybe they will, but it's relatively, hasn't been around for that long, so it's always a good one to look at because there's not that much judicial authority on it. But torture, an act or omission by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person. Intentionally inflicted on a person, an act or omission. So you can see those terms, act or omission, and when you think about that, you can see that it might exclude consequences. You know, and that is, I'm going to suffer in this particular way. The harm against me isn't intentionally inflicted by way of an act or omission, it's just really the end consequence that I'm going to suffer. So if you've got somebody in that category where I'm going to be harmed simply as a consequence, you can see that that's probably, can't just be consequential, that's not enough. You need intention, you need an act or omission. There are these elements that they're broad, but that do need to be satisfied. I don't know if that made sense, but just if it didn't, I guess just stay focused on a need, I guess, for there to at least be an intentional infliction. There are a couple of case examples. Here we go. For degrading treatment or punishment, again, Section 5.1, it's the same language. Act or omission that causes and is intended to cause extreme humiliation, which is unreasonable. So again, we've got, for another form of significant harm, we go back to the same definition section, Section 5.1, and we have the language of act or omission intended to cause and extreme humiliation. There was a case, there are a few Federal Circuit Court cases on this, but a case by an applicant who had contended that being separated from his young children would have, so in Australia, forced deportation, separation is going to have an extreme impact, extreme humiliation, which is unreasonable, and I fall within complementary protection. So you can see how that argument would be made, but there was a finding there that it's not intentionally inflicted, it's not the act or omission really, it's the consequence of that deportation that is going to cause that extreme humiliation. So look, I think for complementary protection at this stage, and we'll look at some of the case law on it later on, but at this stage, just appreciate that the terms are defined, not all of them, but most of them defined further in the definition section. And there's no need for a causal link for our refugee convention elements. That's the big difference. 91R3 does not apply. And the code is, and the law, the code is contained in the Act, exhaustively outlined. Okay? But again, pretty new, lots of novel arguments, and lots of room, I think, to move. Typically, complementary protection typically is dealt with in a few last paragraphs and decisions. So you might not even get consumed by the definition section, the form of harm. It might not even be that which consumes you upon reading it. It might be, well, has there actually been a consideration? Is it sufficient in this case to simply rely upon earlier findings? Is there something that's a bit different when considering complementary protection? Another claim that was made? Another claim that should have been considered? All those things, I think, more usually arise within that context.
You were saying that the complementary protection areas always or generally have this sort of element of intention or motivation. Would you say that arbitrary deprivation of life needs an element of intention? Because that to me doesn't sound like it on the face of it, even though that's sort of qualifying because it has to be faced by the population generally. Would that knock out things like severe domestic violence leading to individuals being killed if they reach that? It's not a risk faced by the population generally.
I think with your example, probably not, but I think that would probably bring us back into the convention definition. So a woman who's suffering extreme domestic violence. But I can see what you mean in terms of just the language, it's arbitrary deprivation. I still think that there'd be problems in terms of it not being something that the entire population is exposed to and there needing to be some type of motivation there. But I see what you mean, and again, I don't think, aside from the definitions in the Act, I don't know whether that's been canvassed in much detail, and might be an area, because you're quite right, to look at, to kind of consider in the right decision. I don't think that they necessarily combine neatly, but I'd struggle to kind of think just at the moment of that type of example. But I will give it some thought, and maybe when we go to actual cases that deal with comp protection, we can come back to that. Yeah, but I think that's a good observation. Is everybody ready to keep on going? Yeah? All right. I think that there are more copies of this document circulating around. We are going to try and just have it on the website, I think, with the video if we can. So, again, it should be easy to access. Before we speak about the judicial review process, in the document you can see that I've extracted general sections from the Migration Act. I've provided over the page a basic chronology. And some of the, in terms of the basic chronology, I don't know how much this will concern us or you in the work that you end up doing here, but it is at least relevant to speak of and to make you aware of it in terms of how people are processed. So the Migration Act categorises applicants and categorises people, citizens, non-citizens. The name has changed many times, but it is unauthorised maritime arrivals, defined in section 5AA, entering by sea an excised offshore place. These definitions and the categories are important in the sense that you need to generally know who can make application for a visa. And some of these people you might not be dealing with directly because we have people in detention, yes? But in terms of the basic chronology, before March of 2012, there was a process, they weren't unauthorised maritime arrivals, but illegal maritime arrivals I think was the term, and there was a process that was outside of the Migration Act, and a person, an applicant, the process that was adopted by the Minister was there would be, I've referred to it already, an IMR, an Independent Merits Review, which is a curious name one might think, but that was its name, and then an IPA, an Independent Protection Assessment. And the way in which that system worked is similar to the RRT avenue, where you have a Department of Immigration officer making a decision, and then if that is adverse to the applicant, you appeal, and Con would have gone through all of that with you. There was another process that was adopted where instead of the department or an officer or delegate of the Minister, it was known as RSA, Refugee Status Assessment, is that right? Or POD. There you go, excellent. And then from there, if that was adverse or negative, you would go to the IMR or the IPA that I just referred to. Now, that whole process was adopted, designed to inform the Minister as to whether or not he should lift the bar that applies. And the bar that applies is in section 46A of the Migration Act. And if you just turn to the list of sections I've provided here. So section 46A provides that an application for a visa is not a valid application if it's made by an unauthorised maritime arrival who is in Australia and is an unlawful non-citizen unless the Minister lifts the bar. Okay, so by virtue of that status, mode of arrival, they are barred from applying. So this process was first adopted, and we still have some IMR decisions. Some people were either released in community detention or on bridging visas. And you know that bridging visas are the temporary visa which just keeps the person's status lawful, okay, while their substantive visa is being considered. So we still do have some of the IMR. Decision is not the right term, it's more so a recommendation. They're not formal decisions, although they look like a decision, okay? The reason that process was probably adopted is it was considered once upon a time before the High Court intervened that it could not be reviewed. And there were many decisions or recommendations made and acted upon that probably weren't reviewed. But the High Court, in a leading case of M61, found that applicants were owed in this process procedural fairness, and also in that decision it found legal error. So with this different, and I've posited them as two streams, okay? The one stream under the Migration Act, we've got the various sections there. The Migration Act is what establishes the RRT. So you've got that, which is the more common, the more regular type of applicant we will be looking at. And then we've got this process, which is not as common because of this chronology, really. It's just not the process adopted anymore. But you still do. I mean, we have sometimes, a person coming in maybe with an IMR recommendation from 2011 or 2012. So you might come across it. What you should know, maybe two main things in relation to that type of recommendation, is firstly, because it's not a decision and it is a recommendation, time limits of review do not apply. When we get to the judicial review process, it will be noted that there are time limits. You've already gone through time limits from the Minister to the RRT, and I have no doubt that Con stressed how important lodging to the RRT on time is. I find it extraordinary, really, that there's just no ability to apply for an extension of time. When we get to the court stage, you've got the prescribed period, 35 days, but if you're outside of that time, you can apply to have it extended. Now, it's not automatic, you have to show certain things, but at least it exists. It's extraordinary that that doesn't apply to the RRT and that you basically miss that enormous, part of your application. It's just terrible. But anyway, with IMRs, there are no time limits to the court, okay? And the next thing, very important, with an IMR, common law procedural fairness applies. When we come to judicial review, thank you. When we come to judicial review and we look at the grounds and discuss those, we will come across a section in the Migration Act which basically says this subdivision exhaustively deals with procedural fairness. So what was done quite a few years ago now is basically the idea of common law procedural fairness, which is much broader, was done away with. And also in the Act, when dealing with RRT decisions, there are certain exclusions about what a person should be given. For example, in an RRT decision, if you haven't been given country information, we were talking about that earlier, if you haven't been given country information, that is not an automatic ground of review. So you can't complain and say, I didn't get this information, I didn't know it was going to be relied upon. There are some exceptions depending upon the type of information, if it's an issue and that type of thing. As a broad principle, no. With an IMR, yes. There were many complaints and there were a lot of cases that were run once the High Court said you can review them, but many times grounds were country information was relied upon and not disclosed. So the ironic end result of this process was, although it was probably really intended to thwart the review process in one way, it actually broadened it. So anyway, that might be something. Just be aware, whenever you're looking at a decision, the first thing obviously is to identify what decision is it, or what recommendation is it, what am I dealing with here? And if you come across one of these, be aware that it operates differently. Now, from the 24th of March 2012, just going to this chronology, it was decided, given the development in the High Court, that a single processing system was introduced. So everybody was to be processed through the RRT system. And again, that's why I'm suggesting this might not be a really common thing for us. 13th of August 2012, I've just noted that as a relevant date. But the 19th of July 2013, you can see my note here of government policy, no exceptions. If you've arrived by boat, you will be subject to the offshore processing regime. Persons arriving a bit earlier, some people have been given temporary safe haven visas. That is an enormous area in and of itself, and one that really does need to be explored in a bit more detail, because the terrible thing about the temporary safe haven visas is a person's given one, and no doubt for the short term that is a good thing that they're on a visa, but it does prevent them from making application for any other visa, including a protection visa. 91K excludes the person from making a further application for a visa. So it is very dangerous, but as I said, a big area, one that we might not consider during these sessions, but you might have discussions about it. I know that the lawyers at the ASRC are interested in it, so it might be something that you get to have a bit of a talk about and consider for yourself. Okay, but that, generally speaking, is the basic chronology in terms of relevant dates and offshore processing. So if we turn to some of the sections, I'm not going to go through all of the ones that I've outlined here. Section 46A, though, is obviously an important one, dealing with the person's status, and it's the bar that I just mentioned. Moving around there, you can see lawful non-citizen is defined, unlawful non-citizen is defined, 13, section 14. Section 47 places an obligation on the minister to consider a valid visa application, but not an invalid one. Section 48A, you can't, or an applicant can't make further applications for a protection visa after it's been refused or cancelled. The only thing to note there, so that's again the bar. If you've made an application, if it's been cancelled, you can't just bypass, for example, the review process and just make another one. But there was a decision probably not that long ago that dealt with complementary protection. So I gave you the date of complementary protection, March of 2012. This particular applicant was pre that date and had their protection visa claim considered on the convention, but not complementary protection because it didn't exist. Right? And there was a whole different process to consider refoulement obligations or non-refoulement obligations. So what the applicant did is they made another application based on complementary protection. And the court there basically found, because there was an argument that it's an invalid application by virtue of this section, you can't make another application. The court, though, clearly outlines in that decision, and I will list it and provide it, that it is an independent basis, as we saw when we briefly went to it. It is quite separate. It's secondary in terms of the timing of the consideration, but it is separate. And that the applicant there and the application made was in fact a valid one. So you can note that, but again, you're likely to deal with applications that are post March of 2012, I would have thought, but we do get clients in here who have perhaps come from interstate, who have struggled to find help from various agencies. Some clients who think that the person calling them, who's the respondent because they've put an application in court in, are their lawyers. You genuinely get some people that are very confused, and it's hard enough understanding the court process when we're schooled in it and when English is our first language. So just take a moment to think, what they must be dealing with. So anyway, note that in relation to Section 48A. Section 48B, Con probably spoke to you about that because Section 48B involves a person who has new claims. Claims weren't made in the first application. So you're basically requesting the minister to lift the bar that applies in order to consider another protection visa application because of these new claims. They usually have to be pretty significant though. But that's Section 48B. Section 65 simply states what the minister's required to do, and that is grant the visa if the criteria has been met, if not, refuse it. Section 91X I've included there just because it does maybe just answer something that I didn't necessarily know the immediate answer to a while ago, but on applications you might see, or even in court cases that you read, you see the XYZ, MZTS, you see versus the minister. This is the section that mandates that in a sense. 91X, names of the applicant for a protection visa are not to be published in either the High Court, Federal Court or Federal Circuit Court. And when you're doing appearances in a case, you'll just commonly refer to the person as the applicant. If you're quoting from something that has a name there, again, you will omit the name and refer to the person as the applicant. Section 479, the parties to the application are the minister and the tribunal. So the Refugee Review Tribunal, we don't have 2 people attending court for the minister and the tribunal. The tribunal will usually just put in a submitting appearance and nothing else. So typically when these matters are run in court, it will be counsel or whoever it is for the applicant and counsel for the respondent minister. Okay? And I've just cited part 866 of Schedule 2. They're the regulations. They're the regs that divide primary criteria, secondary criteria. You might have looked at some of that, the secondary criteria dealing with health issues and other criteria that have to be met. But I'm not going to go into any of that because I do want to move on now to have a bit of a talk about the review process. So if we flip that page over and go to section relevant to decision making. The minister, I've just look at section 51A to 69. They're the relevant sections. And there is some overlap that you'll see. So 51A, we've got the exhaustive statement of natural justice. That appears in the RRT section too. So that's what I mean by overlap. Section 57, certain information must be given to the applicant. This is also replicated under the RRT. Certain information must be given if it's going to be part of the reason for the decision, but it does not need to be given if it is about a general class of persons. I think that's how it's expressed, and there captures the country information, or if the applicant, him or herself, submitted the material in the visa application. So if it actually comes from the applicant, which is unfair when you think about it, because it might be that an applicant has provided a document and the tribunal has a certain view of it and perhaps doesn't put matters to the applicant, and there might be an argument there depending upon what the precise issues are, but on the face of it, it would be okay because of these provisions, and that is, in that case, the applicant provided the document. So if we move on from the minister sections and then go to the Refugee Review Tribunal, and that is first outlined in section 411 of the Act, and that is applicant has the right to seek review of a decision by the minister to refuse an application. And again, very strict time period, approved form, and I actually think that you guys you've filled out a protection visa application form and an RRT review form, I think was one of the last forms that you completed. So you'll be well and truly familiar with that. But if you were curious as to the section of the Act, there it is. 414, there's an obligation by the tribunal to consider valid applications. The tribunal is not obliged to consider an invalid one, such as one that is submitted outside of that time period. It wouldn't have jurisdiction in that case. Section 415 sets out what powers the tribunal has. Affirm the decision, vary the decision, remit the matter for reconsideration, and set the decision aside. Section 422B, this is the part that I referred to before, exhaustive statement of the requirements of the Natural Justice Hearing Rule. In other words, what is provided for in this division and in the Act cover the in terms of those matters, it is covered in the Act. It's as provided for. It's as the Act spells it out. Now, on that point, if we consider some of the other sections, there's section 425, And that provides that the tribunal must invite the applicant to a hearing to appear in person to give evidence and present arguments. That's just it's foundational, isn't it? So section 425 must invite the applicant to a hearing, to appear in person, give evidence, present arguments. If you have a case, for example, where an applicant, adverse findings are made and the applicant is not put on notice or alerted in any way. So think about a scenario where the first decision of the minister is obviously adverse to the applicant, so it's obviously against him or her and they've appealed. But on certain fact findings, they make certain findings there. Then the tribunal considers the case, also against the applicant, but on a different basis and not finds differently to what the minister did, the delegate. Different factual findings are made. It's certainly open for the tribunal to do that. They're not bound by that decision. But an applicant for review is entitled to be of the view and understand that the findings made below, unless told otherwise, unless alerted to it, are the findings that are going to be made in the tribunal. Okay, so if you get a decision and it's suddenly the delegate saying, I accepted that this relationship existed and it's pivotal, the claim is pivotal to the overall protection visa claim, then you've got the tribunal member saying, I don't accept the relationship, but not a question was put to the applicant. And it doesn't have to be, it can be done in a number of different ways, but some type of doubt, some opportunity to present an argument, that's a very clear example of a denial of procedural fairness. How does it apply though, and how would you argue it in court given there's an inhibitor or something that constrains us, section 422B? It would, and I would suggest that you try and pull it into section 425. And that is that it's in contravention of that section when these significant findings are made, adverse findings, and the applicant is not put on notice. So section 425, I think, is an important section to be aware of because it offers some scope and room to consider those procedural fairness points. 424AA, just working back because I've skipped them, and 424A, they're the provisions about the type of information that needs to be given to somebody. And I mentioned to you that it mirrors, if you like, the minister provision, that's section 57. So if there's an obligation to inform an applicant of information that is relevant and is going to be a reasonable part of the reason for the decision. Sometimes applicants are given 424A letters, and it uses that language. This is relevant, this is going to be, might be, a reasonable part of the reason. 1, 2, 3, 4. Here's your opportunity to respond. Now, it's not going to be country information, we know that because that's excluded. It's not going to be information that an applicant, him or herself, has given. It will be something else that is important that there is an obligation on the tribunal to put forward. It's done either in writing or, in more recent times, 424AA provides for it to be done orally at hearing. 426 deals with the taking of evidence, so calling a witness. And in the tribunal review form that you filled out, was there a section dealing with any witnesses to be called? I think there was, yep. And so you can name the person there. There is not a positive obligation to call the witness, but there is an obligation to have regard to the wish of the applicant to do so. And again, you know, witnesses and the way in which they're treated, whether they are in fact called, what their evidence might have been relevant to, all of that stuff. Like when you're looking at one of these cases and you think in your mind, what was relied on by the applicant? What did they want to have happen? And you can see that he asked for a witness, but the phone connection was bad, or they made an attempt but couldn't. You would turn your mind to that and have a bit of a think about whether somehow this has caused, you know, just ask yourself simply, an unfairness, and then have a bit of a think about the process and whether regard was had to calling the witness and what the witness would have said and the relevance of that to the overall claim. So I'm talking in fairly broad terms there, but I think that when there are witnesses that are an issue or part of an application, you've got to isolate it and have a bit of a think about it. So 426A allows the RRT to make a decision without the applicant if the applicant fails to appear at his hearing as scheduled, but gives the RRT discretion to reschedule the hearing. There have been, so you can see from that section that a decision can be made without the applicant being there if he or she fails to attend. And you might have a decision where it is made without the applicant. The applicant might have moved, failed to inform, somebody may have had a dodgy agent who didn't relay things. There are a whole number of real scenarios. With those decisions though, a reviewer is still obliged, or a tribunal member is still obliged to consider the claims. So even though the applicant's not there, and we've had this arise sometimes, have a look at what material they did have and was it considered. But in cases like this where there has been some type of anomaly, some procedural anomaly, you would really give that some specific thought. There are sometimes cases where adjournments are actually sought. It's not just a matter of somebody not knowing about it. They've wanted an adjournment application. In a case of Lee, LI in the High Court, it dealt with the Migration Review Tribunal, but a very similar provisions bind that tribunal. And in that case, the applicant had wanted an adjournment, and what she had done, some business visa, I can't recall the exact visa, but she had sat some type of skills test, and they got it wrong. So they actually got it wrong, and what was required is for her to sit it again, to go through that process, and then have her hearing, because it had to be fulfilled to meet the criteria of her visa. It was necessary. And the tribunal there made comments like, well, I'm not going to adjourn it, and she's had plenty of opportunity, and comments along those lines, where the High Court just said, well, you know, that's a procedural error. You can't just, I mean, there might be a good reason to not adjourn a person's case, but certainly nothing was disclosed there, and there was no real balanced or consideration given according to the Act and the duty to give a hearing and all of those matters to that applicant. So when we look at jurisdictional error shortly, we'll be looking at substantive error and procedural error. They're generally the two categories that will occupy our time. Okay, but just be aware of those types of decisions where a person might say to you, or it might be apparent from the decision, that either they weren't there, or they were sick. You get that sometimes. I was sick, I want an adjournment, and see what type of consideration has been given to that. So that deals really with the RRT and the Migration Act. There are other sections, certainly, I haven't reproduced them all, but from what I see, they're probably the ones to be aware of, because Again, they might provide us either at least with a guide to know what should have occurred or an actual ground to argue a breach of a particular section. 424A being the obligation to give material, as long as it's not excluded, is one example, or 425, where I gave the example of procedural fairness type points, is another one. So Con spoke about the tribunal hearing and the way in which they're run, and I think spent a lot of time hopefully dealing with credibility issues and how to prep your client and all of those matters, because once you move away from the RRT, that's really the end of it as far as merits review is concerned. Judicial review and merits review are very different, and a criticism sometimes levelled against applicants is that this is a way to try and attack the merits of a decision. You just don't agree with it. So it's very important when we're looking at these to try and find a way that it may fall within that substantive type of error. And by substantive, I mean, getting the real chance test wrong, getting the relocation test wrong, membership of a particular social group, those types of matters, or more procedural. That's a common complaint and something commonly falling from respondents. This is merits review. Another one is Wu Shang Liang is a case that I know very well because it is a common case where you can't read these decisions with an eye attuned to error, and so that's a common case that is levelled against an applicant. And that's right. I mean, I'm not suggesting that we completely, I probably am suggesting that we pick apart a decision. Certainly when you read it a few times, you've got to do that. But if there's a spelling mistake, or you don't just pick them apart and think that's going to get you too far. And you've got those cases that are not helpful, that do say you're not to read something looking for that error. But at the same time, the cases don't say that you've got to give it a beneficial construction for the respondent. They don't say that if something is missing, we've got to fill in the gap in favour of the respondent. You've got to be a bit more balanced than that. But we'll come to all of that shortly. In terms of the courts, I just want to go through perhaps some of the basic venue type issues. The first thing, I guess, is the jurisdiction comes from Section 75 of the Commonwealth Constitution. And who was it that had the pocket constitution? There you go. And it provides for the original jurisdiction in the High Court, okay? And the reason why the High Court has jurisdiction is it is a matter in which the Commonwealth is a party in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth. So that is the source, and that's why. These are the remedies that we're seeking, and an officer of the Commonwealth is obviously involved. But we don't run to the High Court every time there's an application like this, although there was talk about trying to get rid of the federal court's jurisdiction. So if they tried to do that, we would be running all the time to the High Court. The reason we typically go to the Federal Circuit Court is even if we were to apply to the High Court in, say, an RRT matter, they will transfer the matter back. We go to the High Court if the review or the application is against a primary decision, which is the delegate's decision. Okay, it's then that we would make an application to the High Court. And as you know, the structure is the delegate is the first officer that makes the decision, and that's the decision that we appeal to the RRT. So if you have somebody who has missed that deadline, and the centre has had this a couple of times. We had this one woman who was terribly ill. She was living interstate. I think she had psychiatric issues, and other people, really legitimate reasons as to why they missed that time, but that was the end of it. So what we need to do then is look and read that delegate's decision. Sometimes you can get delegates' decisions, obviously, that are reasoned. They're a bit sloppier though, in my experience. So it is important to, and I say that a lot of them are overturned at the RRT stage. Not always because they got it legally wrong, but I think it gives us a bit of insight. So if you've got somebody with just the delegate's decision, then applying similar principles, looking for similar issues, because don't forget the real chance test, all of that, it's the same law, it's just a different decision maker, we would go to the High Court. That's not the most common application here, but it definitely has happened, and we've got a couple of pending matters at the moment because of that, because of the process that exists. But the Federal Circuit Court, excuse me, Section 476 of the Migration Act, Subsection 1, Federal Circuit Court has the same original jurisdiction in relation to migration decisions as the High Court has under the Constitution and what I've just taken you to. So that's why it's the Federal Circuit Court. It's also more expedient. You keep costs down for the applicant. It is the first avenue really, unless certain exceptions apply. The Federal Court, and it's Section 476A of the Migration Act that deals with the Federal Court, it only has jurisdiction to consider migration matters if it has been transferred from the Federal Circuit Court. So if there is a transfer of proceedings, that's when it is vested with jurisdiction. Otherwise, the Federal Court in migration matters might deal with an AAT, Administrative Appeals Tribunal appeal, and I referred to Article 1F before. You might have that type of case that goes through that process. But the Federal Court, again, ordinarily is not, and in fact you're prevented because of that section. It's not where we go. It's where we might go if we lose in the Federal Circuit Court and we apply to the Federal Court for an appeal. Time limits, Section 477 of the Migration Act, provide for 35-day time limit in the Federal Circuit Court. But as I mentioned before, the Federal Circuit Court may, by order, extend that 35-day period as the Federal Circuit Court considers appropriate if an application for that order has been made in writing to the Federal Circuit Court specifying why the applicant considers it's necessary in the interest of the administration of justice to make the order, and the Federal Circuit Court is satisfied that it is necessary, specifying why, and is satisfied that it's necessary and in the interest of the administration of justice. So, A, you've got to specify why, and B, it has to meet that test, and that is it's necessary in the interest of the administration of justice. Now, typically if we're making an application for an extension of time, because you might have somebody who is either a month out of time, 6 months out of time, a year out of time or more. You will not make a separate application. It will be, this is our application form that you get off the internet, and I'll bring a draft one that's completed maybe next week and we can have a bit of a look at that, but they're very easy to access just off the Federal Circuit Court website. And you can see Application Migration Act, court's jurisdiction under section 476 of the Migration Act, which we've referred to. The pseudonym, remembering the person's name is not going to be on that form, the court will place there. And then migration decision details, so details of the decision, in other words, Refugee Review Tribunal, date of decision. Application for extension of time, and you can see that that appears here, whether or not you tick that box, and grounds of application for extension of time. So it might be that you need to provide a bit more detail, but you can see that it's all the one form. So if we have somebody who's out of time who wants to apply and we're able to assist, it would all be done here. With these forms though, we would also always attach an affidavit with the tribunal decision, but if it is an extension of time issue, we would also go through with the client, get instructions, why was there the delay, and you can go through that. There might be, again, many reasons, but you'd want to make sense, you'd want to have some kind of chronology. The bigger the delay, the more difficult as a general rule, but not impossible. And my own view is if you have a case that is meritorious, if you have a case where the ground is quite a strong one, when we consider the test provided for in the Act, which is necessary in the interest of the administration of justice, it's likely that it could be met if you've got a case like that. And in your affidavit, the client wouldn't canvass the grounds, obviously, in it, but would offer certain information, including the concerns upon return to the country. You know, my life is at risk, I fear persecution, harm, and that will typically be something that is considered on the day of the actual hearing for the application. You might be opposed, might not be, but it's typically all done at the same time. Okay? Excuse me. And on that point, again, if we're dealing with that other avenue, the IMR RSAs, does the extension of time application have to be made? No. Technically no, because it's a recommendation, not a decision, so it doesn't apply. But you'd still probably want to provide an affidavit explaining some of that delay. Sometimes they can be 2-3 years. We've had that here at the centre, a 2-3 year delay, and you just want to, in case there's an argument that it should be refused on discretionary grounds, you'd want to canvass why there has been that delay. And sometimes people say, look, I contacted Pilch, or I went here, I got a negative advice. And again, these advices are, you know, it's not black and white, and I'm not going to stand up here and say that everyone that I've looked at is, you know, and I know everything, because opinions do differ. But there have definitely been cases here, where they have been given negative advice, and it has been subsequently challenged and consented to. It's actually been conceded by the respondents. So it's important when you're dealing with that delay issue not to look at somebody and think, well, 2-3 years, forget it. Get details and look at that decision. Yep. Now, certiorari, quashing the decision, getting rid of it. It's an unlawful decision, so that's the remedy that we're seeking. Mandamus, compelling a decision to be made according to law. And these forms, helpfully, an injunction also restraining the minister from relying upon the unlawful decision, and a declaration to that extent, a declaration that it is wrong, it's unlawful. The forms themselves, actually, when we go, have many people seen these forms? Yeah? Okay. Grounds of application for extension of time, which we've discussed, interlocutory, interim or procedural orders. We'll come to that next time, I think. But typically, if you're within time, if you're making the application, you go straight to final orders sought by the applicant, and you can see the boxes. Writ of mandamus, declaration, injunction, and here certiorari, an order that the decision of the tribunal or minister be quashed. Okay, so you'd tick those. Grounds of application here. We might have and do have clients that come in and their time period is about to run out. Not only their time period, you also have to remember, and this would have been, you would have discussed it last time, bridging visa applications. Sometimes they're tied in to it all and it's 28 days, so you have to get those instructions from the client, and if it's a shorter period, then you shouldn't go off this period, go off the shorter period. So it might be that you have less time, and it is important to protect a person's rights. While the Federal Circuit Court and the other courts, all of them, have the discretion and ability to extend that time, and that is the lodgement time, it's not automatic. You might not get the extension of time, and you don't want your client placed in that position. So if we have somebody who attends at the centre and their time is going to run out tomorrow, and it is considered that the centre should assist them at least, either on the night, give them an advice, or come back next week, somebody will look at it. It depends on how the logistics of the way everything's going to operate. But if you've got a situation where it's impossible to give them an advice, you would fill it out. I would suggest, and there'll be some kind of pro forma, but the decision is affected by jurisdictional error. Number 2, I am awaiting legal advice, pro bono legal advice. Just state it there. The courts, I think, would prefer it to be stated rather than have all these dodgy court applications that are clearly not drafted by the applicant, but it's in their name, and they're the ones that they've gone off and paid somebody ridiculous amounts, and you don't know who's behind it. So I would suggest something like that, just clearly stating going to get legal advice to protect an applicant's right of appeal, which makes sense, is ethical, and again makes sure that their interests aren't compromised in this process. Now, the tribunal decision, as I said, would be attached to this. The affidavit that you take from the client would be generally very brief, unless it includes this whole extension of time issue. And I guess in terms of the overall process and the way courts work, the applicant will go in person and file the form, 3 copies, and there will be a fee waiver form that we'll probably have to fill out on their behalf. Not a very exciting thing to do, but again, off the internet, I've got shakes, yeah, I agree. But again, usually not a problem. I mean, we do have people struggling. They usually without difficulty have that fee waived. So that will need to be completed. The application form, 3 copies, copies of the RRT, everything in 3 lots, off to the court, the registry, filing the application, getting certified copies is what will happen, and it will be served. And again, unless there's some kind of volunteer program that will help, sometimes applicants will go in person and will serve it on the Australian Government solicitor. Might not stay with them. There are other firms that do the government's work as well, but that is the place, and there's an address for service. And a directions hearing, when these are filed with the court, is nominated by the court. So that is generally what happens with the application. Yep.
My understanding is the federal court's going online for their filing. Is this something that won't? Or, because I remember we had a session on it at work and not everything will be, but it's going to get to the point where the majority of things have to be filed online.
Yeah, look, I think that, I personally think that's probably going to be very helpful. In terms of this work, I think that there will just have to be a decision by the law team of the ASRC as to what practice is followed. I have a paranoia myself about faxing things, RRT applications. I would always say to somebody, well, it can be faxed, take it in. Court applications, it's the same thing. So I'm a bit old school, I think, in that regard, but that probably would obviously save a lot of running around and that type of thing. But we'll wait to see what their position is, and I think that they'll come to a general position in relation to that. So it will get to the point though where that is the only method of
There's a couple of things that won't go that way. I just
Yeah.
can't remember precisely what they were.
Yeah, okay, well that's interesting.
The registry's not going to accept certain things.
Yeah, okay, all right. But anyway, until that might be completed or finish, this is generally the process. And the directions hearing is nominated. The client will come back in, and obviously more work is to be done if it is, and we'll go through what material we might need to look at a decision. In terms of the directions hearing, if the centre is acting, often direction hearings are vacated. A person doesn't need to attend if this is negotiated with the other side, and the benefit of that is reducing stress for any type of applicant and also reducing costs. And you'll typically get a timetable, the applicant to serve written submissions or amended application, the applicant to serve an amended application, which just brings me again to our document here. We're not stuck and confined to this. We'll have an opportunity to amend it and to state the grounds that will be relied upon. Okay, but it's important obviously to get this in because this is what starts the process.
How long does it usually take to get a directions hearing from when you file?
I think direction hearings probably take, at the moment, I think a few months, a couple of months. And then a hearing date. I don't think that you'd get any hearing dates this year if you're filing now. I'd be surprised. But yeah, I think that's generally how long it takes. There's a bit of a delay. And as I said, typically if we can vacate those, if we are assisting the person and helping, there'll be that timetable and there will be opportunity and time to consider the case. We'll also receive a court book from the respondent minister, and the court book in it should contain most of the relevant material. So beginning from the protection visa claim itself to all the statements made, the submissions made, everything you guys were talking about to that lead up, how to prepare for an RRT, how to prepare for the minister, all that stuff in writing should be in that book, along with the decisions.
So a directions hearing can just be done on papers?
It can, yes. But again, if nothing is done, if there's no intervention, if there's no lawyer speaking to the other side, then the date will be there and we would be telling our clients to go. I mean, if they've got a directions hearing and it hasn't been vacated and there's nobody representing them, they must go because they're at risk of matters being struck out and we don't want that to happen. So, can I just get a time check, guys, from anybody? What time is it? 9:15. Okay. I'll start just to wrap up. I think Con told me 9, but I think you guys go over that a tiny bit, but I'm not going to keep you here any longer. We will, on the next occasion, I hope that has given you some of that, just the foundation in terms of the convention, the Act, and the courts, and why we go there. Sometimes they're just questions that hang around, we don't necessarily know the answer, but that's pretty much it. Next time we will go and through grounds of review, how to start an assessment, what in the world jurisdictional error means. Okay, it's very, very difficult to define. It is usually, and what it really concerns is exceeding the limits of power. And again, think of it in terms of those two categories, procedural limits and substantive limits. I think it just helps to start getting some type of framework, and we'll go through all those matters on the next occasion. So does anybody have any questions that they want to ask now? If you do, after you've had a bit of a think, feel free to next week. But I hope it's been relatively clear and not too much kind of dry information. Any questions? Everybody okay? Yeah? Excellent. All right. Well, thank you very much for your attention. You guys have been great. I'll see you next week. Thank you.